residential use should occur, along with certain community and recreational uses to serve the residents of the district. And we pointed out the low density here, across from Cedar Croft, Gateshead.
Sure.
And then RR, recreational residential, which is the purple, correct?
Correct.
That is created to provide for a mixture of residential, recreational, and commercial uses, with emphasis on commercial uses which relate to the recreational opportunities or which serve the residential properties. The district will be located primarily along or near navigable waters on lands suited for development. So, trying to comply with those two definitions, a thought would be to make the east side of the lake similar to the west side of the lake. Meaning, if we were to look at the perimeter road, which is paved, and you follow it all the way down to Hemlock, and everything from this paved perimeter road towards the water remain recreational residential because it meets the definition, and everything from the paved road east, the discussion would be, should it be R1, residential low density? And that's what I'm wondering could be potentially be an end state. And if that were an end state, knowing that recreational residential allows the current use of a camper by itself without a residence or without a permanent structure, does R1 allow the same?
No. In the R1 district, the use of a recreational vehicle on a vacant parcel would be a special exception, not a permitted use.
Which we have done in some, like Gateshead, for example, we did that a few years ago, if you remember.
Mm-hmm.
Okay. So, if in fact this town board were to pursue that, which sounds like a viable option, would you agree, Dave, that it is
By
potential?
ordinance, it's an option that the town has, correct?
If this board were to pursue doing that, what procedures, besides what is listed on 17.81, starting with filing petition, what would need to occur?
As far as the township moving forward on this,
Potentially meeting that end state of rezoning everything
Okay.
east of the paved perimeter road.
okay. So, let's see. Let me get
Oh.
this package for you guys.
Thank
Yeah. So when you look at the procedures, filing a petition, it does indicate that a petition for amendment of this ordinance may be made by any property owner in the area to be affected by the amendment by the town board of any town where the ordinance is in effect. So that would be the town of Cedar Lake. So with that, the township does have the ability to submit petitions to rezone property that is not under the ownership of the township. Now, with that, there's, when we look at the rezonings, procedurally, what we've done in the past is if, let's use non-metallic mining as an example as far as how we've handled rezonings of large areas, where the petitioner, so to speak, is a mining operator. And through the process of either buying property or leasing property, there's multiple parcels being involved. And in that situation, we have the aspect where the property owner signs off on the petition itself as the property owner, and then the operator is the agent. We look at those parcels individually, so we hold individual public hearings, okay? There could be, numerous parcels and, quite a bit of acreage, but we look at those individually as far as the property owners. When we rezone property, we can look at a petition of having multiple parcels under the same ownership. Okay, so if I wanted to rezone multiple parcels that I own, I could do that with one petition. I don't have to, as a property owner, come in and rezone them individually, okay? So we have a situation where the town would like to rezone a large area, or, work towards bringing this to to the R1 district rather than the recreational residential. The ordinance does allow the town to file petition or petitions, okay? And so what we're looking at is that rather than one application that would encompass the entire area, we're looking at individual rezonings, okay? When you get down to section 1781, it talks about public notice to owners. Indicates that if a petition for rezoning has been submitted by someone other than the owners of record, a copy of the petition and public hearing notice and an explanation of the rezoning procedure shall be submitted by registered mail to the owners of record at least 30 days prior to the public hearing on the petition. Okay, so let's say that the township chooses to rezone a particular piece of property, all right? The town can be the petitioner, all right? Not being the owner, this office would have to send notice to the property owner of the petition being filed and the reason, notice of the public hearing and an explanation of why the rezoning is going to be held. And that has to be within 30 days. So there is that, as far as the ordinance is built in, but rather than one application that is going to encompass, numerous parcels of numerous owners, it would be a process of rezoning parcels by property owner. And like I say, if somebody has multiple parcels, that could be under one petition, okay? So it's just not one application is not going to, in effect, be petitioned to rezone the entire east portion of the lake shore. So you can understand that aspect of it?
Yeah, that's how I understood it.
Okay. So, so procedurally, we follow the same procedure of any other rezoning, where the petition is filed, we process that, we review it, we establish the public notice that is published in the newspaper.
How many days? 2 weeks?
Yeah, it has to be published for 2 weeks, and then we schedule that into our calendar with the Barron County Zoning Committee. That committee meets, it's scheduled to meet on the first Wednesday of each month, if there's action items, a reason to hold a meeting. So in this particular case, it's a matter of, how many petitions are going to be submitted, okay? Of how much additional information, because this is a little different than a standard application. We have to give notice to the property owner, okay? Within that 30 days, we have to provide an explanation of why why the petition has been filed, okay? But procedurally, it would get in front of the zoning committee, and the zoning committee, as in any other rezoning petition, we hold public hearing. And at that public hearing, they would take testimony in favor of, in opposition to, and discussion as far as the merits of rezoning that property to whatever the district is, okay? At the end of the day, the zoning committee makes a recommendation. They do not decide to rezone it or not. They vote, and that recommendation is then forwarded to the County Board of Supervisors. So with a rezoning, it is rezoning is an amendment, and it's an amendment to the official map, which requires county board action. So the county board would vote on the recommendation submitted by the zoning committee. And based on that vote, it's either they approve the recommendation, or they basically disapprove it, send it back for reconsideration, or basically telling them to change the recommendation, and then they would vote on the positive as far as the rezoning. So that's the standard procedure. Doesn't matter what it is. Yep.
When you talk about the zoning committee, is that the Board of Adjustment?
Nope.
No.
The Board of Adjustment is a separate committee that's a function of this office. The zoning committee, it's a quasi-judicial board made up of citizen and county board supervisors. That board holds public hearings in reference to administrative appeals, variances, and special exceptions. The action of the Board of Adjustment, being a quasi judicial, think of it this way, that they're the judge and the jury. They're taking the testimony, they make the decision, that decision is their decision. It does not go to the county board for consideration. But that's dealing specifically with administrative appeals, variances, and special exceptions. The rezoning, that's the zoning committee. The zoning committee is made up of county board supervisors. They are the oversight committee of this office. And as that committee, like I say, they hold the public hearing, they make the recommendation, that recommendation is forwarded to the county board for consideration. Ultimately, thumbs up, thumbs down as far as the rezoning.
And they go into action when needed, the zoning committee.
Correct, yeah, typically it's monthly, but there are times where there's nothing, there's no agenda, and I'm not gonna have a committee meeting just to have a
Sure.
committee meeting. There has to be something productive out of it. Yep.
How many people are on the committee?
The committee is a 5-member committee.
Okay.
Just, for clarification, let's say this gets to the point it's beyond the public hearing, beyond the committee, beyond the zoning committee, and now you've got your 29 supervisors or a quorum listing everything. Can they approve, disapprove, or request more information?
Basically, the public hearing is held with the zoning committee, okay? When it gets to the county board floor, they're voting on that recommendation. It's not the time or the place to rehold the public hearing,
Okay.
okay? If the supervisor in that district has, interest in it, they should be in attendance at the county, at the zoning committee public hearing, okay? So it's really a matter of, what they're gonna do is they're gonna, consider the recommendation of the zoning committee, and then based on that, make their decision.
And if they need more information or they send it back, you mentioned they either make a decision or they send it back for another
Let's just say,
opinion. Do they say what they are missing or?
well, let's say that let's say they vote, there's a recommendation not pertaining to this, but this in general,
Okay,
that the zoning committee makes a petition in favor of a rezoning,
okay,
okay? Or it could be the opposite.
right,
So it comes to the Board of Supervisors as a recommendation to approve. Based on the vote at the county board floor,
mhm,
if there's not enough votes to carry that,
Mhm.
okay? What happens is that it has to go back to the zoning committee.
mm,
The zoning committee has to reconsider. Well, they're not reconsidering, they're just basically changing their recommendation.
mhm,
They change their recommendation at the next meeting from a recommendation for approval to recommendation to denial. The reason for that is that the county board has to act on the positive, okay? So when they vote in favor of, okay, they're either gonna be voting in favor of the approval or in favor of the denial, okay? So that's the process.
right. How many people are on the county board?
29 members.
Okay.
If this gets to that point where the county board approved based on the zoning committee's recommendation, what would happen after that as far as who would enforce the new zone? So let's say the zoning is adopted, which makes using a parcel of land for the purposes of camping in violation of the zoning laws. Is there a time frame for individuals that are camping to vacate? Or what happens if we get to that point?
Well, let's go through our paperwork. Okay, so we went through the rezoning aspect of this, okay? I provided a copy of the Barron County petition for rezoning, okay? Typically, what we're looking at here with this application, it is signed by the property owner, okay? To be honest, we never had,
This one did?
This one.
yep, that one, there's this copy.
Okay.
Yep. And so with that, in my time here, I've never had a township request to rezone property. So the form may, if the township is signing as the agent, we'd have to, basically clarify that, because you're not signing as the property owner, okay? But nonetheless, this is just our standard petition for rezoning. We have our town consideration form, which I'm making the assumption the town would be, not opposed to it,
Yeah, this
okay?
this is what we see.
Yeah, this is what you see, okay? We can come back to this information here. But what I'm trying to get to is, 17.17, nonconformities, okay? So what we have is, we have property, currently zoned recreational residential. Recreational residential, currently, it allows the use of recreational vehicles on property, without a principal structure being a cabin or a residence, okay? And that's the permitted use. Okay, so let's just hypothetically, with that, we're gonna now petition to rezone properties. Let's just use a property in particular. So we're gonna change it from a recreational, a residential that has a permitted use for the purpose of recreational vehicle use. If it's a lot that has been basically permitted as such, okay, now we're gonna rezone that to the R1 district. The R1 district allows it as a special exception. But what we have is a pre-existing use now, okay? We cannot zone out pre-existing uses. So when we rezone from the recreational residential to the R1 district, the uses that are in place now become pre-existing non-conforming uses. They can continue until such time that until that use no longer is on the property. And then the legal question is, when does that occur? When there's a permit issued for a principal structure, then the use is changed, okay? But the use of that as a lot of recreational purposes, that continues even though the district technically has been changed. So we can't, quote unquote, zone out a land use.
So it's like Grinch.
I don't like the frame, okay,
I'll
it's
bet
a
you
word,
did.
it's a word, but
I know.
it'd be a pre-existing,
Pre-existing non-conforming.
non-conforming use. With the rezoning, now it becomes a non-conforming use, but it's pre-existing, and it takes that status. And it's it's a pre-existing use until such time that it's no longer a pre-existing use.
That's a tricky one.
Now, on a lot that is undeveloped, okay, but it's a vacant parcel, and it's currently zoned RR, and now the zoning is changed to to R1. At that point, there is no pre-existing use, okay? There's been no permits establishing the use of that property. At that point, that parcel would be, as far as the issuance of permits, they'd have to be in compliance with the new district, the residential 1, okay? Which would be, as far as recreational use, a special exception in that district. See the
Oh, yeah, I got
difference?
it, yeah.
Okay, so it's not a matter of, with the rezoning, that use disappears, it becomes the status then becomes pre-existing non-conforming use.
But the unique circumstance that we're dealing with, and this is based on some conversations I've had with some attorneys, is that this would likely need to be adjudicated in court of law, because the fact that there are hundreds of parcel owners using their property for the purpose of camping, they are there under false pretenses. They violated their contracts, they violated their deed, they violated the covenants and restrictions. So just because you broke the law once, doesn't mean you get to write it out later.
Okay. And to be clear, this is the Barron County Land Use Ordinance, okay? If they have their permits to have a recreational vehicle on that property, they're in compliance with the ordinance. What other covenants, restrictions apply to properties throughout the county, it's not part of the Barron County Land Use Ordinance.
So the town could go into litigation against the beach club for failure to enforce their covenants and restrictions,
That's
and
legal.
then seek all financial damages because of it.
that's a legal question. You
Okay,
have-
but and that goes beyond our scope here is to talk procedure.
Correct.
Okay.
Yeah, I'm looking at the Bear County Land Use Ordinance, and if we're looking at, you know, the possibility of rezoning parcels from the current zoning district of recreational residential to R1, we have to go through that process, okay? And through that process, the town, just like any other applicant, is going to have, you know, convincing testimony, purpose for that rezoning, okay? That's, you know, as far as the, getting a recommendation in favor of, you know, of the zoning committee.
Mary and Corey, any questions for Dave? I think we've gone to the end of the procedure, which is good, unless there's something else you think.
The
we should
procedure,
know.
that's, yeah.
That's it. Okay.
Yeah.
Any questions for Dave? I don't have any more questions.
Well, yeah, I guess I've got all kinds of questions, but, let's start at the beginning. Do you know of any other areas in the county that look like this? Any other circumstances that are similar to this, where, I mean, I'm looking at the map behind you, and in every single body of water, it looks purple right around the perimeter of it. But you look at the town of Cedar Lake, and you've got the mass extending beyond the boundaries of the water to the east. Can you think of any other places in the county that have something similar to this, where you have almost a subdivision zoned RR1?
I mean, this is a unique area.
Right, and so I guess the reason I ask that is because I would question what the original intent was. Why it was originally, when the subdivision was created, why was it zoned the way it was to begin with?
I want to comment. There's been some folks that have researched this through the records going back 40-some years. And some of these parcels were actually agriculture. Let's confirm all this. Recreational. They've been a number of different categories since the Beach Club entered into existence. So why they went to this, I have no idea. And
Do we know when that happened?
I don't know off the top of my head. Because it, you know, we adopted the Barron County zoning, I think it was in 2002. 2002, and that had occurred prior to this, I believe.
Yeah.
A lot of stuff would need to be researched.
On the back, on the end of your packet there, this map represents, there's two things. There's the map here of the township as a whole, and then there's the insert, okay? And this map was established back in basically 1968 with the adoption of the Shoreline Protection Ordinance, which was mandated by the state of Wisconsin.
That's this one, the insert, correct?
There's two, yeah, that's the insert, okay? So in 1968, the state mandated shoreline zoning. So Barron County adopted the shoreline ordinance in April 1968. And at that time, the jurisdiction, the mandated jurisdiction was 1,000 feet from any lake, 300 feet from any river or stream. Okay? I wasn't here in '68. Okay?
You weren't born.
No?
But this is the map, that was drafted in 1968. The jurisdictional line was 1,000 feet from the lake, okay? So, back in 1968, this is the idea that they had, okay? So, up until, 2002, when the township adopted, okay? The jurisdiction of the ordinance was strictly the shoreline areas, area within 1,000 feet of Cedar Lake. Beyond 1,000 feet, we had no jurisdiction, okay? Now, there's always been that coverage, dual coverage of the ordinance and the Loch Lomond covenants and restrictions, okay? That's always been there. So in 2002, when the town adopted, this is basically, there's been no changes since the adoption in 2002. So as far as what the intent was, I don't know, Ken, but this is what the map and shows the intent was, okay? And even in the ordinance back at that time, it did allow, as a permitted use in the recreational residential owner occupied travel trailers. The difference at that time was seasonal only. But since 1968, this has been, a recreational area. That's,
The problem is, at no time did any board, beach club boards, ever come to the township and say, hey, we're thinking about requesting a campground permit, et cetera, et cetera. It all kind of happened subversively, covertly,
where's a campground permit for
to
what?
establish a campground.
Where's the campground? Where's the campground?
The campground is throughout
No,
the
no,
entire
no,
purple
let's
area.
zoom in here, okay? Let's zoom into the campground, all right? The current standards for a campground, you need a minimum of 5 acres. There's not a single parcel here that I see that we can establish a campground. I know that you use the term campground, that's your position. This is not a campground. This is recreational use that has been something that has been on the books since 1968. I know that there's been a lot of it out there, okay? And to be honest, is that gonna be the hurdle when it comes to rezoning? We're trying to basically, reclassify the area to eliminate what your view is a campground.
Not really. You can look at it the other way. Perhaps the reason to do that would be to entice and motivate homeowners to come in and build, because just like the judge, now we're getting off the tangent. Just like the judge ruled, it's a housing development. So therefore, the town might come to the decision to say, you know what, we do want to encourage building, we do want to encourage construction, obviously there's more revenue and all these other things that go along with that. So no, it's not, let's get rid of campers, it's let's attract home building, because it's a housing development, it's not a campground. And we're going too far down the road.
Yeah, no, that document right there says a lot. The original drafting of the subdivision states that it was designed with permitted use of campers on a seasonal basis. And people probably aren't gonna like it, but I couldn't care any less about the covenants and restrictions of the beach club. That is outside of my scope as a town board member. So I pretend like that doesn't even exist. All I care about is the zoning and what authority the town has within that jurisdiction. If the beach club has rules that supersede or are more strict than us, that's on them to enforce, not me. So I pretend like the covenants and restrictions is a separate thing. What I'm concerned about is the subdivision was created, apparently, with the intent of permitted camping on a seasonal basis. Has that scope ever changed?
To say that that the development was created for the purpose of recreational use, I don't know, okay?
Sure.
This ordinance was adopted in 1968.
And is that written by the town, that ordinance?
No, this is the Barron County.
Oh, that's, okay.
This was a county ordinance that was mandated and adopted by Barron County, in
Okay.
1968.
Okay,
So this was in effect at the time that these developments were created,
okay.
okay? So was the intent of the subdivision to create, lots for recreational purposes? I don't know. But the classification of the property that was rezoned within the shoreland area, okay, was zoned recreational residential that allowed this use,
Sure.
okay?
Yep.
So I mean, I don't know what the intent of was with all these subdivisions and such, but when it was created, 1968, that 1,000 feet buffer was already zoned recreational residential. The ordinance was already established that allowed that the recreational vehicle usage.
Sure, and I track with you on that, and that makes sense, but what I'm concerned about is what extends beyond that 1,000 foot. Obviously, none of us, even in this room, can explain what the intent was, because none of us were part of that decision-making. I'm assuming, I shouldn't assume things, but the thing that I guess kind of hangs on me is I'm trying to play the devil's advocate here. If I were on the other side of this, if I were, say, a developer and I owned a dozen lots over in that area, And if I bought those lots knowing that they were zoned residential recreational, if somebody were to come in behind me and tell me, we're gonna rezone that now, and you're gonna restrict my audience to sell to, I would not be very happy about that. I would not be happy with somebody telling me that my land can only be used for certain things when I bought it. Regardless of the intent, I bought it with the rules in place that they are, being RR1, that it could be used for that. So that's kind of what I'm hanging on is, there had to have been a reason that they extended beyond the 1,000 foot and make it RR1 and not, the first 1,000 feet was RR1 and then it converted to residential. Are you still with me on what I'm getting at here?
Because the 1,000 feet, obviously, doesn't go all the way to the end of what you're showing us.
So can you measure out 1,000 feet just so we can get an idea of,
What part of the proposal?
well, you can just click your ruler and drag over 1,000 feet.
You've done it before.
We've got
Scale.
tools here.
He's got fancier tools than we do.
Let's just make this simple.
I've seen you do this before, Dave.
This is shoreline zoning, so this here shows the 1,000 foot area. And what I'm gonna do is I'm gonna get rid of the zoning at this point, went the wrong direction. Okay, so this here depicts the 1,000 feet, okay?
Mm-hmm. Okay.
So this is, this is the area that was mandated by.
You're almost, pardon me, you're almost going, I had said the potential scenario of the perimeter paved road, you're basically showing us one more block over.
Yeah.
Right. And I'm assuming if a parcel is split by the line, the entire parcel would be part of it?
No.
The parcel could split?
I mean, if you're looking at back when, prior to comprehensive zoning, if there was a lot that was split, okay, it was that jurisdictional line. If you built on within that shoreline overlay area, you had to comply with the ordinance. If you built outside of that line, you were unzoned,
So any bit of your property, if it's within, you gotta comply.
See,
Is that
okay,
what you-
no,
You
let's
know,
just say,
just the activities that are happening in that zoned portion.
Okay.
If it's happening in there, then it's subject to the
So
ordinance.
so if we're looking
If
at
it's
these,
outside of that, then it
let's
does
use-
not apply.
let's use this as an example. Prior to the town adopting comprehensive zoning in 2002,
Mm-hmm.
the extent of zoning jurisdiction was right here. So in this particular parcel, okay, if they were to locate a structure or any land use activities within this area that's hatched, that would have been under the jurisdiction of the Barron County Zoning Office. Beyond this area was unzoned. The only thing we would have had, jurisdiction over would basically be sanitary and, land division. Okay? Those are county standards as far as those ordinances. So back prior to 2002, all of this was unzoned, okay? What happened out here besides, sanitary systems going in or further subdivision, we didn't really have anything to do with that area.
Okay. So in 2002, when the town signed on with the county, would the county have gone with just a map like this and setting them up as RR1, or?
To be honest, I wasn't part of that discussion. That was the former administrator, okay? I don't know what the discussions were. I don't know if it was the intent of the town to keep everything consistent in that area. I don't know. Paul Flotta, the former administrator, worked with the township through that process.
Okay. It's kind of a mess, huh?
I do have a question on one.
No, go ahead.
That document there was not included in our packet, right, Dave?
This one,
No, the one.
This one here?
oh, that
No.
one, right.
Let me scan it, please.
I didn't get the second map either.
I'll give you that.
Okay.
Share.
All right,
You don't have,
I'll have it here.
thank you.
And thank you for putting all this together. I know these meetings, you spend more time preparing for the meeting than you do conducting the meeting. Well, that might change
Never change.
Not in there.
So is anything, I mean, it sounds like that's basically the same as what it is today, isn't it? I mean, maybe it's a little bit more detailed today, but
This you're talking about?
yeah, as far as,
Well, the use of recreational vehicles, it has evolved countywide, okay?
Okay.
But didn't you say it's not 12 months, it's seasonal?
Back, at that time, it was seasonal.
Yeah.
Okay? And, you know, so that ordinance countywide has evolved over the years, and the current ordinance, you know, is, which you have in your packet, 1736, is much different than this. Okay?
other than it's the same that you can do either a residence or a camper.
Right.
That part has stayed the same.
Right, it's still, in that district, use of a recreational vehicle is still a permitted use.
Sure, and if I remember correctly, if it was zoned residential and somebody wanted a special exception to put a camper on there, there was some pretty strict rules, wasn't there, for
Well,
that?
that's what we
The
did.
couple,
Yeah.
the two guys that came in,
Gateshead, and then they had to pay like $500 or something.
yeah, there was
Yep.
a much more expensive permit, and then there was a much tighter time frame tied to it, from the zoning office.
From what I
It
remember.
had nothing to do with covenants or restrictions, it was from the zoning office, right? Like they had to build or break ground within so many months
And
or.
finish.
Right.
And that is site-specific, applicant-specific, okay? The Board of Adjustment, let's see. I'll stack this stuff up really good here, guys. But with the special exception, oh, yeah, I have in your packet, 1773, special exceptions. And it goes through, you know, the application process. The board conditions, the board may make the granting of that with specific conditions, okay? All right, and it's dependent on the board, dependent on the circumstance of the property and such. So the board, being that quasi judicial body, has the ability to put specific conditions on an approval. It could be a time frame of, you know, a certain amount of number of years. So that's part of their process.
When you say board, you're talking,
The Barron County Board of Adjustment. So when we look at, you know, if property is rezoned on the east side here to the recreational, the R1 district, the property owner would have the ability, because then it changes, okay, so you have a vacant parcel, they have the ability to apply for a special exception to locate a recreational vehicle on there.
Mhm.
How the board decides that, it's up to that, you know, up to them.
But the same procedure is what Corey was referring to.
Correct.
The other part.
The same procedure as we had.
Same cost, same town's got to approve.
Same cost, same public hearing, the same legal notice as required with a rezoning, okay, that mandatory two-week public notice, yeah.
The thing that a court of law may have to decide is what would a reasonable person assume? For example, a board member back in whenever, when the covenants restrictions were established by the Lackawanna Beach Club. A town board member at that time, that person reasonably assumed that the board of directors would actually enforce their covenants restrictions and that their members would actually comply with covenant restrictions. Then it made sense that they would proceed with recreational residential. There'd be no reason for them to say, what if this happens, or what if that happens, and all this other stuff. And that's not what we're gonna figure out here today, that's what we're gonna have to figure out on our own as we go. Not on our own, but with the town board and legal assistance. Any other procedure questions? Mary?
no, I think I get the idea of how the whole process, would roll out. I guess the only other question I would have is, and it's maybe something you can't answer, but what would be considered a reasonable justification for rezoning? I mean, have you, I get if it's zoned ag and somebody wants to turn their field into a subdivision, they wanna rezone it. I get that, that's a reasonable justification, but how would one even have a good reason to go from RR1 to residential? I mean, I'm trying to think of what kind of reason you could come up with that would even be acceptable.
And I guess that's, what the town's gonna have to figure out before they present the first application, okay?
Sure.
And Marshall and I were not voting members on the zoning committee. So it's a matter of what the zoning committee is going to proceed, consider to be a reasonable,
Sure, but that, I guess that works out to our advantage, because then we can bounce ideas off of you without any conflict of interest. You know, you could actually offer input as a non-voting expert matter. So,
And my question would be, if we want to motivate or attract traditional housing developments with permanent structures, changing from RR1 to R1 would be a justification. But that's, we don't know, we're not gonna figure that out yet. It's gonna have to be figured out as we go down the road. And I'm just telling you guys right now, we're not gonna do this by ourselves. If we decide to proceed, it's gonna be getting in the subject matter experts and the attorneys and have that. This is, what we have to figure out is, how do we do our job? Because right now, we've got X amount of folks that can't stand what we're doing, and X amount of folks that can't stand that we have to stop what's going on. So we are caught in the middle. So, just like Judge Boyle said, look at the facts, leave the emotions out, just look at the facts. And you may not agree with the facts, but you gotta make a decision on the facts. We just learned a whole nother complication, this 1,000 foot, that.
I didn't know about that.
I mean, as far as 1,000 feet, with the township being, now under comprehensive zoning, okay, that doesn't really matter.
It doesn't?
No. In an unzoned township, okay, where a township is unzoned, okay, let's look at
Bear Lake.
Bear Lake, Lakeland, okay? Hang on here. The more I move it, the slower it gets. Let's just kind of zoom out here a little bit. So we have Bear Lake, Lakeland Township. Both of those are unzoned townships. When you click in the shoreline zoning, okay, those are the areas of jurisdiction that the county has, those shoreline areas. If either one of these townships were to adopt Barron County Comprehensive Zoning, then our zoning applies to the entire township, not just those areas. So the 1,000 feet that I was showing you along the east shore, that had, that jurisdictional line, was used prior to 2002.
Before
Okay.
we changed.
Yep, so that.
So it doesn't matter.
It does not matter, okay? It's because the township adopted zoning
Zoning.
is township-wide,
Right.
okay? That's the distinction, so that shoreline zoning is pertinent for the unzoned towns. When the township has adopted, then it's the zoning, the entire zoning of the township.
Does it make you feel better now you don't have to worry about that?
Well, I guess I wasn't overly concerned about the 1,000 feet.
Good.
I'm still trying to wrap my head around the idea that Barron County is the zoning authority for the entire township, as you just stated. For the town to come through and request a rezoning, it seems like we've kind of already given that authority away, but we're not the zoning authority anymore, so.
But that doesn't mean we couldn't ask a question.
Sure, but I mean, I guess, how is it any different than a neighbor asking that you rezone the adjoining lot, you know what I mean? Do we have any more weight than a different, a private individual coming in as the town board? I
Well,
mean,
that's where it gets complicated
I
in
don't
terms
know.
of
That's
what
where you
is
get into
his
that
job.
pre-existing use thing.
Yeah,
That's-
I,
that's-
as far as a request like this, Corey, in my time here, I've not seen a township apply for a rezone,
Sure.
okay? So, you know, I really don't know how, you know, I'm kind of, you know, procedurally trying to work through this too,
Sure.
okay? But
Yeah,
But as far as the ordinance, it does allow the township the ability to make that petition, okay? There's, you know, on our end, we have to do the proper notification of the property owners that the petition is, you know, for.
sure.
So, but yeah, that's the,
Well, so in 2002, we handed the zoning back to Barron County. Is that endgame? You don't ever get a chance to say,
I don't know if he
thought about
had,
it,
I
I
don't
wanna
know,
get it back.
I don't know if he handed it back, okay?
Mm.
The only zoning in the township,
Oh, we
was the
just kind of shifted
shoreland area,
responsibility.
you're unzoned.
Okay,
It was decided that the township wanted wanted coverage over the entire township, okay?
okay.
As far as, getting out of zoning, the only way that that can occur is if the county were to make major revisions to the Barron County Land Use Ordinance.
Oh,
Major revisions as such that it requires readoption by each township. At that point, the town may choose not to readopt. That occurred back in '77. There were towns that had adopted zoning. There was a major rewrite in '76, and through the adoption process, there were a couple of townships that chose not to readopt.
Because they were given the choice and we could say yeah or nay.
Well, yeah, at that point, are you gonna adopt a new
The new one or
comprehensive
just-
ordinance or not? And they
Right.
chose not to.
There's actually, the process is defined within the Wisconsin Towns Association.
Yeah, I thought I saw that every
Information
5
Library.
years or something.
It's still a little confusing, but
Yeah.
just what Dave is talking about is
Okay.
correct. That's because he has everything memorized. But there's,
Yes.
the whole procedure's out there. What we're trying, I think I may speak for Corey and Mary when I say that we're trying to do our due diligence to make sure we have turned every rock and looked at everything possible, because we've got two opposing parties out there. And regardless of the outcome, we need to let everyone know, here's where we're at. And therefore, you know, the town board will take some sort of action or not take any action. But today, I don't know, very helpful to me.
Me
You
too.
guys could all make and listen.
If you think of
Learn a lot.
questions after
Especially me,
this
since I
discussion,
knew
give me a call. I mean, it's all out there in the ordinance, and I think I provided, trying to do everything, is giving you those, you know, what I'm looking at, trying to guide